Thank you for joining us at Toy Fair University. Up now, we have Common Litigation Risks for Toy Designers with Armin Ghiam. Armin?
Thank you very much, Anne. I am Armin Ghiam. I'm a partner at the law firm of Hunton Andrews Kurth. Our office is here in New York. We have close to 22 offices all around the country. My specialty is in intellectual property law. I work on patent cases, trademark cases, copyright cases, and trade secret cases. I have litigated a lot of toy cases, and today I would like to cover some of these litigations and hopefully provide some insight about litigation as it comes to the toy industry. There we go, it works. So before we get started, I wanted to provide an overview about what intellectual property law covers. Intellectual property law is basically coming from the Constitution, where it says to promote arts and sciences, the government is obligated to provide limited or limited exclusive rights to inventors and authors for their discoveries and their writings. Because of that clause, we have patent law, we have trademark law, we have copyright law, and we have trade secret law. What is patent law? Patent law essentially covers two things. It covers functionality. A lot of times you have a functionality in a toy. For example, you make a toy that sends a ball from point A to point B in a different and new way. So you can patent that concept. And that would be a utility patent. Sometimes you have a design patent. And that design patent protects the ornamental aspects of the toy as it comes to that device, as it comes to that object. So for example, you could have a design patent for a chair, and you can protect the design, the pattern on the chair using a design patent. Trademarks, everybody knows about them. They're the logos, they're the brands, they're the names. They're, the less known one is the trade dress, which I'm going to be talking about. Basically, they designate a source of an object. So if you see an object has a particular brand on it, you know who made it and where it's coming from. Copyright law covers expressive aspects of, it could be writing, it could be a movie, it could be a photo, it could be a statute. You use copyright law for those. And trade secrets basically are confidential information that are created in your business, and it imparts some sort of benefit, some financial benefit, and you can use that to protect those aspects of your business. Now, all of these things are great. Why do you need to have a clearance program? And the answer is very simple. When you have all kinds of protections, like the ones that I discussed, and like other ones that we have not discussed, it is not difficult for you to come up with a new design concept or a new product and get sued. So, in order to prevent that from happening, you would have a clearance program. The job of a clearance program is to look into existing rights and ensure that what you have created or what you have designed is not infringing anybody's protected rights. And the last concept I wanted to cover before we move on is IP enforcement. Once you amass a portfolio of intellectual property, once you have a couple of trademarks, a couple of patents, or a couple of copyrights, you might want to have some exclusive zone for yourself and push everybody else out of that zone. That is where the IP enforcement programs come into play. And this is why you see a lot of lawsuits, folks trying to sort of maintain their exclusivity. Sometimes they're obligated. Under trademark law, you're obligated to police the market. Sometimes you're not. And there's a financial benefit or a financial motive behind it. And that's why you decide to engage in IP enforcement. All right. Now with the basics done, let's cover a couple of litigations that took place recently. This morning when I was about to walk out of the door, my daughters, Ella and Kaya, they had me to bring this Labubu plush toy to show it to you. They thought it would be beneficial for this presentation. This is precisely the toy that's being litigated in this case. So what's happening in this case? Labubu or Pop Mart is filing a district court litigation. I think this one is in the Northern District of Illinois against 189 e-commerce stores. What they are alleging is that these e-commerce stores are selling counterfeited products, they're selling products that are infringing their trademarks, and they are infringing their copyrights. Pop Mart or Labubu, they claim exclusivity in the design or trade dress of the plush toy. They also claim rights in the name Labubu, that's theirs. And they have also taken photos of the plush toy, and they claim exclusivity in that. So this particular lawsuit is a Schedule A type of case. What is a Schedule A type of case? Schedule A case are the kind of cases where you draft a complaint and you name a lot of defendants in them. A lot of defendants. Many, many, many defendants. So in this particular case, there are 189 defendants. But who are these defendants? These defendants are essentially small store owners on Amazon, on eBay, on Temu, on online platforms where they're trying to sell nearly identical or identical products such that they could be classified as counterfeits. In this case, many of the sellers are foreign sellers. In a typical Schedule A case, it is filed under seal, so you don't know it's filed. The lawsuit is litigated for a couple of months. Some sort of a temporary restraining order is granted, and the assets of the sellers are frozen. Once the assets are frozen, they approach Amazon, they approach Walmart, they approach Temu, and they ask for the money to be transferred over. So now, this is a particularly effective tool in combating foreign counterfeiting in particular, because you can name a lot of defendants. It's relatively cheap. You file one of these cases, you go after 180 people, 190 people. Relatively cheap, easy to do. On the part of the brand owner is something you should consider. On the part of the distributor, it's rare for you to be sued in one of these cases unless you're selling a product that's nearly identical, or unless your product is a counterfeit. In which case, the clearance object is the objective is pretty easy. You got to make sure that when you bring a product that is identical to your competitor, have an attorney take a look at it and receive legal advice on it. Otherwise, you might be sued in one of these cases. All right. The second case I want to talk about is Pop Mart v. Danbar Cool Things. Somewhat of a similar lawsuit. Unlike the other one, here we have only one defendant. The defendant here is Danbar Cool Things. The lawsuit was filed in December of 2025. The main allegations are trade dress infringement and copyright infringement. And in order for you to better understand trade dress infringement, I put up there the definition of the trade dress that Pop Mart claims to be the dress of their plush toys. And I'm going to read. A wide mouth that stretches almost to the ears with an exaggerated grin that reveals 9 sharp teeth, 9 sharp white teeth, with the 4th and 5th teeth centered. 4th and 5th centered. Contrasting with the wide grinning mouth, it has a prominent brow, overhanging the top of the eyes, giving the impression of a constant frowning expression in the eyes, just like me, constant frowning. Eyes that are slender, oval-shaped vertically, and also vertically aligned, that are one-eyed width apart. A nose that is a small, flat, upside-down, rounded triangle, 2 closely spaced ovoid ears that narrow at the top to a rounded point sticking up from the top of the head, and a plump and oval-shaped body, and the rest of it. Okay, so as you can see, this is very detailed. Typically, trade dress is not this detailed, but they came up with a very detailed definition. And I have my suspicion. The reason is that there are a lot of plush toys. You want to distinguish your plush toy, and that's what they did. Otherwise, it would have been difficult for them to claim exclusivity or distinctiveness for this particular dress. So now, on the left, I have the infringing product. Well, on the left of each set. And on the right, I have Labubu's product. You can see it. I wanted to go over a couple concepts. It's not so much about the law here. I think what I wanted this crowd to take away is, number one, the standard here. The standard for trade dress infringement is likelihood of confusion. Likelihood that a consumer who observes, let's say, the product to the left would be confused as to the source of the product vis-a-vis the product on the right. In other words, they would take it as if they're coming from the same source. It's a little bit subjective, isn't it? Likelihood of confusion. Despite the detailed definition, it's in the eye of the customer. and how they feel and what they think it's coming, or where they think it's coming from. Same goes for copyright infringement. The standard is substantial similarity. Again, what is substantial similarity? Are these two substantially similar or are they not? So what I want to highlight here is that there's a degree of subjectivity when it comes to copyright law and trade dress. And that could work to your benefit if you're a brand owner, if you're an IP owner. You would want to bring a claim because it's subjective. There's no easy way to get rid of it. The lawsuit is going to go for a while. Or if you are someone who could be sued and you're selling products that could be similar to your competitors, keep in mind that these are the types of claims that could be brought against you. The other factor that I wanted to highlight here is the registered nature versus the unregistered nature of IP. Here, PopMart does not have any registration for the trade dress. I believe they do have a registration for the copyright, but not for the trade dress. Why does it matter? Well, if you have to seek a registration, your IP is kind of defined. You can't really morph it into different shapes when you're about to file a lawsuit against someone. On the other hand, if your IP is not registered, you can define it however you want to define it. So for example, the trade dress definition that you saw, you define it based on your competitor's product. You define it as broad enough so that it reads on the competitor's product. At the same time, it gives you some exclusivity. So keep in mind that copyrights, because it's an actual object, you don't have as much looseness when it comes to registration. But for trade dress, you basically define it the night before the lawsuit. And that gives you a lot of flexibility if you're a brand owner or if you're a creator. Okay, the last part of it is the litigation outlook and effective clearance program. So in order for you to have a clearance program in this space, there is some element of subjectivity. Risk is always there. My mentor used to say, you can always hire a first-year lawyer, and they would tell you, don't do something. It's easy to say, don't do it. But the question is, when would you be able to, let's say, come up with one of these products and at the same time not get a lawsuit? So there's some subjectivities as it comes to the risk that applies here. And for litigation, if you're an IP owner, you want to bring a claim, it is subjective. It is going to go for a while. I've been on a couple of these cases. They go for years. Your competitor has to spend a lot of money. They really have to be committed to the product to want to continue with that case. All right. Next one, VIP products v. Jack Daniels. Let me show you the product first, because it might make sense to see the product before I talk about it. The one on the left is supposed to be a parody of Jack Daniel on the right. Bad Spinnels v. Jack Daniels. The old number 2 versus old number 7. I mean, to me, it clearly looks like a parody. I guess some people don't see it as a parody. Okay, so what happened here? So Jack Daniels sent a cease and desist letter. I think they sent a cease and desist letter. VIP Products did something that was somewhat unusual. They jumped the gun. They filed a declaratory judgment action. They filed a lawsuit. They said, you know what? We don't care about your letter. Let's figure out, let's have a court say this is not trademark infringement. In their view, they had a strong parody case, right? Well, Jack Daniel, they counterclaim for trademark infringement and dilution by tarnishment. They're claiming that their brand, which is the design of the bottle, is being tarnished because of this parody toy. Now, so that you know, Jack Daniels here owns federally registered trademarks covering the whiskey bottle design and the label, the trade dress to the label, in addition to the brand name. The brand name obviously is protected. I could be talking about this case for days because it went all the way to the Supreme Court, came back. There was so much back and forth in history. For the purposes of this audience, I thought 2 sentences matter. VIP Products argued that the toy is a parody. And I'm hoping that you can see it tries to be a parody, or it is a parody. And the Supreme Court disagreed. The Supreme Court said the bottle looks so much like Jack Daniel's bottle that you are essentially using that bottle as a sort designating object. And so you're infringing the trademark. So what's the point that I want you guys to take away? The point is, it does not matter whether or not you think it's parody. There is some brand owner out there who is going to be upset about what you created. And they could send you a cease and desist letter, and if you jump the gun, you could be in litigation. They've been litigating this case, I think, for close to a decade. It's been going back and forth, up and down. So one thing that you should consider When you come up with an object that is similar to your competitor's object, pay very, 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 very close attention, because someone at your competitor is going to see your product and they're going to pay a lot of attention to it. And someone like me is going to get a phone call. And the phone call is, come up with something. And when they ask us to come up with something, we will come up with something, and we bring a lawsuit. It does not matter what your intention is. It does not matter how you feel about it. It does not matter what you wanted to do. A lot of times I get a phone call from clients that say, hey, we want to pay a tribute to this particular product. We want to pay a tribute to something that's old. Our intentions are benign. We're not trying to make fun of it. Someone at the brand owner could take it the wrong way. You could be in a lawsuit. So if you're copying somebody's product, or even if you're making fun of it, talk to an attorney. The other one here is Jack Daniels started this by sending a cease and desist letter. Jack Daniels is a famous brand. Everybody knows them. These days with social media, you got to be very, very, very careful when it comes to sending letters. You could be sending one of those menacing attorney letters. The next thing is, it's on Facebook, and people are commenting on it. And you can't take it down, because you did send the laws, so you did send the cease and desist letter. I think Jack Daniels is one of the companies that they send somewhat nice cease and desist letters. And that's something I want to bring it up. Just because you can put legalese on a piece of paper, it might not be the best strategy, because you end up losing the court of public opinion. That's not what happened here, but I brought it up because I know Jack Daniels sends nice letters. I've been involved in enforcement campaigns in which we send nice letters, and you would be surprised how much compliance we get. We get a lot of compliance, because nobody likes getting one of those letters that says, you copied my brand, it was willful, it was intentional. You can just send a nice, benign letter, and it does the job. All right. The last case that I wanted to go over is T-Turtle v. Just Play. So what are we dealing with here? This is an octopus that is reversible. If you go from the image from the left side to the right side, it's an octopus that on one side it has a happy face, on the other side it has maybe a sad face. So this design was patented by T-Turtle. They patented this design. They felt there's some value in it. They did that. All right. The reason I place this case here is because specifically I wanted to point out that while trade dress and copyright is somewhat subjective, patent infringement, on the other hand, is an element-by-element analysis. And for everybody's benefit, I put up the claim so that you can see what exactly the claim is for this particular product. The claim is a body including first and second material layers defining opposing first and second surfaces, the first and second material layers defining a sealed cavity, the sealed cavity positioned between the first and second material layers, wherein the body reversible between first and second positions to alternatingly present the first and second surfaces as an outer body surface defining an exterior of the body. The other of the first and second surfaces alternatingly defining a stored body surface defining an interior cavity within the body, wherein the exterior of the body defines the same shape in both the first and second positions. This is precisely what you got to show in order for you to show infringement. Element by element. Every one of these phrases has to be present in the product. It has some benefits. It does not care about the look and feel. It does not care about the smiley face. It cares about the functionality. So if you're creating, let's say, a mechanical toy, that could be a useful tool for you to be able to protect that. On the other hand, if you are creating a toy that you care about the color and the look and feel and those kind of things, perhaps trade dress or copyright is the better avenue for you to protect. One thing to consider about patents are expensive. In order for you to have a patent like this one, probably you have to spend, I don't know, maybe $10,000, $15,000, $20,000 to protect that. And you're hoping for the patent to offer you some sort of an exclusivity. When in reality, when you get a patent today, you don't know what your competitor is going to be copying 10 years from now, 20 years from now. So it might work, it might not work, you never know, but you have to spend the money right now, today. And one last comment about clearing the patents. Patent clearance is pretty straightforward. There are search companies. We approach them. We ask them to conduct a search. On mechanical devices, it's a lot easier. On digital, computer-related, and software products, it's a little bit more complicated. So if you think your functionality could be protected by a patent, please do consider consulting an attorney. And I think This is it. I got 22 seconds. I will be there. If you have any questions, I'll be happy to answer your questions. Thank you so much, and thank you, Kelsey, for giving me the opportunity to come back again. Thank you.